if we should have a page break between each of the aggravators. To me, this all reads like it's all part of one long, very long definition.
Yeah, break between each.
Between like 1 and 2 and 3, put them on their own page. I guess we don't have to. It's just, you see where it says E and then 2 and then 3 and then 4, they're all indented differently, so
I see what you're saying.
it appears as if perhaps someone has inadvertently used a number instead of a letter or vice versa. At least if we can just have the indenting the same again. I'm sorry. This might not bother anyone but me. What's that? Because I think, wait a minute, because you know when you read a statute, it's like 1A, B, 16, 26, and you're like, you have to keep going back to see, wait, am I on a new subsection, or is this all part of the same? That's the only reason I don't want them to think.
Well, would it look better for the court if you look at on page 5, number 3, the third aggravator, if the words engage in the commission of a burglary are pushed over underneath the word?
It would. It sounds like Ms. Ciappone might be on the same page as me, so maybe she can help you.
She's got the printed copy and we've got the computerized copy, so that's the problem.
Like as it stands, if you look on page 5, number 4, heinous, atrocious, and cruel, looks like it's a subsection under number 3 because of the way it's indented. Do you see what I'm saying?
Yeah.
I don't mind coming down and showing you if that would be easier.
Underneath 3 and 4, if you want,
If you look
burglary should be that should be aligned with. I agree. It should be lined up with the same way it is for aggravator 4.
the actual aggravators, if they can all please be in the same space with the same indentation, and then the definition be in the same, so that it doesn't appear as if 4 is a subsection of 3.
Okay.
Okay?
Yeah.
Other than that, it looks good. Other than that, I know I just sort of gutted your format.
My problem is I'm looking at the computer screen instead of the printed. It's much easier to tell when you're looking at the printed. So.
Look, at the end of the day, if the words are all there, it's fine. I'm just...
No, but now see, by looking at the printed, I know immediately what you're talking about.
See, doesn't it look like subparagraph 4 is a part of section 3? And
Gotcha. Yep. Fine. This is fine.
Well, some of this
So for cold calculated and premeditated, judge on the bottom of 6, we'll move so that they're aligned. You can, it doesn't look as though that's really picked up.
I think 5, 6, and 7 are... It's only confusing when there's more than one number on the same page.
I'm sorry, Judge?
It's okay. It's only confusing when there's more than one number on the same page.
Right. But are you all right with the way these 6 and 7 work? Or
Yes,
okay.
because there's no other number, so it's pretty easy
Okay.
to figure out what goes with what, in my opinion. anything that either side wanted to add as far as the aggravating circumstances instruction is concerned that has not already been made part of the record yesterday?
Yes, ma'am.
Okay.
So on page 8, at the top of the page, it ends the further instruction for this aggravator number 7.
Wait. I'm sorry.
Page 8.
I'm on page 8.
Okay, so at the top, you see that's the ending of the aggravator from the previous page.
It should be together. I agree.
Well, no, I don't care about that part. My objection is if you continue and the court wanted these headings, aggravating factors, it then goes into victim impact evidence, which, although the last sentence says you may not consider this as an aggravating factor, it's in the aggravating factor section. So I think that needs to be on its own page, maybe a heading that says victim impact. I don't really care, but I don't want it to be in the section of aggravating factors. And then after that, we could do a heading that says reasonable doubt, because the rest of this section is just the reasonable doubt instruction.
Your Honor, in the jury instructions prior to these jury instructions, the Supreme Court had victim impact towards the end of way toward the end of the instructions, past the mitigation and whatnot. Then they moved it to where it is now in 2018. That is the current position for victim impact, going by the court's current instructions.
Right. I'm not suggesting that it be moved. It's just, and the standard instructions don't have the headings the way the court wanted, and I don't have any problem with that. I have a problem with victim impact evidence being in the aggravating factors section of the jury instructions if there is going to be a section.
Well, because it's what aggravating factors is and is not. And I can start by saying I'm going to define what an aggravating factor is and is not, if you want. But I think what the state is saying is if we hadn't have organized it the way I asked, it would still be all part of the same instruction. We just wouldn't be organizing it in this way.
Right, but the page says at the top, aggravating factors 6 of 8. I don't see any reason why we can't put that on its own page with a heading that says victim impact, and that's the only paragraph on the page, and then we start a new page that can just be called reasonable doubt.
Except that that's not all reasonable doubt that follows, Your Honor. It talks about what an aggravating factor is and how to arrive at it. So it's really a misnomer to call that section that follows reasonable doubt.
Okay, then just do this. We'll take off my organization heading. We'll just do we'll just do the numbers, the page numbers, and take off. We'll put aggravating factors on the first page and then take off aggravating factors off all the rest and mitigating circumstances. We won't do it that way on any of the instructions then. My intention was not to have it mislead anyone. It was just to keep it organized. But I see what you're saying. So we'll just put aggravating factors once. Okay?
Okay.
Ms. Curtis, is there any objection to just removing the title?
No, ma'am.
Okay. So, I don't know. I think taking that off, and then that means we have to take it off of all the other subsections. Okay, let's just take off the headings, and they can figure it out by page number. Okay. All right. Mitigating circumstances. Is there any? First of all, with regard to mitigating circumstances, I had the opportunity yesterday to read the Beasley case, and pursuant to Beasley, I am finding that the death of the biological mother, who the defendant met for the first time while in the Broward County Jail after the incident, is not to be considered as mitigation, and I appreciate the defense not mentioning that in closing because I had not made my decision yet. So I don't know if that paragraph is still in here.
We took it out, Judge.
Okay. Are there any other corrections, amendments, or additions other than on mitigating circumstances? Just have that title on the first page, please, and not on the other pages. State, is there any other objections, amendments, or additions?
No, Your Honor.
Well,
Defense?
The defense did list their new mitigators today, so
They did, you said?
they did. They sent them.
Well, these are your names. The last thing you sent me today.
This is what I sent you.
Yeah.
Are those included in the proposed instructions that you gave me?
Yes, these, as far as I know, are the defense's final mitigators.
Right, it's the same that we originally sent. We just took out the one about meeting Ms. Woodard. We took out the one about rule out autism, and we just added one that he pled guilty.
Okay, State, is there any objections,
No, Your
amendments, or
Honor.
additions? No?
No, Your Honor.
Defense, any objections, amendments, or additions as proposed?
No, ma'am.
Okay? Let's go to,
When you go to 17, Judge, that was where you said, when we finished mitigating, you said, well, just push it down, but don't give it a header. That's why there's no header for 17.
that's fine, since we're taking off really the headers anyway, okay? So is there any objection to the standard instructions on page 17 and 18 as proposed, other than was already mentioned yesterday?
Nothing to state, Your Honor.
Defense?
No objection.
Okay, weighing the evidence. I would like to, is there any objection to keeping the heading weighing the evidence page 1 of 2, weighing the evidence page 2 of 2?
No, ma'am.
No, Your Honor.
All right, is there any objections to the way it's proposed, weighing the evidence? Other than obviously what was raised yesterday, if anything.
Nothing to state, Your Honor.
Defense?
No, ma'am.
Okay, rules for deliberation. Page 21, is there any objection, amendment, or addition, State?
No, not on 21. I do have 22. I have something to say.
Okay, defense, page 21, any objection?
No, ma'am.
Page 22, State, you said you have an amendment?
Well, I just wanted to say to the court, we'll take out the words judge reads verdict form. If that's where the court wants to read, I just left it in there to make sure if that's where you wanted to, go ahead and read the verdict forms. If we'll take that out, obviously, and we'll just leave it as they are as follows.
Sure, I can figure it out, thank you.
That was the only thing I just wanted to bring to your attention, and we will add in 2.1A.
Okay, so let me just look at the exhibits.
There was a discrepancy between the way the Florida Supreme Court wrote the death penalty instructions when it came to, they didn't put in there picking a foreman. They just, all it says is, in just a few moments you'll be taken to the jury room by the court deputy when you have reached decisions in conformity with these instructions.
I'm sorry,
The
Mr. Klainer?
form should be signed and dated. I'm sorry. In just a few moments at the top of page 22. In just a few moments you will be taken to the jury room by the court deputy. When you have reached decisions in conformity with these instructions, the appropriate form should be signed and dated by your foreperson. I know in the regular jury instructions, there's like a section where it says one of the first things you'll do when you go back.
You were going to add that, were you not?
I thought the court had said that, but I wasn't 100% sure, so I
Let me,
didn't put that in.
Let me, I thought I referenced the instruction yesterday. Let me,
I went and found, I have the instruction.
is it 2 point, I don't remember.
I think it's 3.13.
3.13, submitting the case to the jury?
I think it's 3.13. I'm looking at my text. Yes, it says the first, in just a few moments, you'll be taken to the jury room by the deputy. The first thing you should do is choose a foreman or foreperson who will preside over your deliberations and so forth. So 3.13.
Does it say somewhere in here that if they have a question, they're supposed to give a note to the bailiff?
Yes.
Where's that?
It's 1, 2, 3. Oh, and all the state's instructions. I don't have it, Judge. Or the instructions.
Why do they leave those very important things out? You said it's not in states?
Oh, I don't know. I don't have a copy, Judge. They're fine.
There was a notation for them to, if they had issues with the exhibits that we talked about yesterday. But it also said if you need to communicate with me, send a note through the court deputy signed by the foreperson.
Where is that?
Page 23 toward the center.
Okay, perfect, thank you.
And Ms. Basham, you said the instruction regarding picking the foreman is 3.13,
3.
submitting case to the jury.
Yes, it's the first paragraph that talks about the foreperson, picking the foreperson.
So this, what's not in our forms is the first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard.
I mean, is there something that says there shouldn't be a foreperson in a penalty phase trial?
No, I think we should add that,
Okay.
those sentences into the paragraph.
Otherwise, I imagine they might go back there and like, what is the first thing we're supposed to do? At least if we tell them, pursuant to the instructions, it makes it clear.
We already have the part at the end of that.
So just the part that is not included,
I'll add it.
please add it.
And I believe, Judge, if you look under where I had originally put Judge Reed's verdict form,
What page, please?
22,
Okay,
there's a paragraph that starts during deliberations.
okay.
Okay. It looks as though the standard 3.13 has more language in it than the Supreme Court has for penalty phase. They have, in addition to what we have,
This is like the first amended complaint versus the second amended complaint. Did anyone ever have to go through those and see what's different? And sometimes it's one word. Anyone do civil?
not a lot.
The 15th amended complaint, what's the difference? So,
I think what I see is missing is until you have reached a verdict, you must not talk about the. No, that's, I'm sorry.
You know
You
what?
are not able to communicate the restrooms. If a juror goes to the restroom, the deliberations should stop until the juror returns. That's what's missing.
I don't remember that part. That must be a new addition.
So if you would like.
Where is that,
I think-
3.13?
Yes, ma'am.
Gosh,
Submitting the
man,
case
do you
to
remember
jury.
that? I haven't tried a case for over.
I feel like you've read it before in case
The bathroom thing?
Yeah.
Oh, you know what?
Oh,
You're in
Miss-
timeout. Charlene's in timeout. She said the juror can't have a knitting needle.
She's gonna kill me.
She's She's a rule follower. No kidding. I'm just kidding. Okay, sorry. You know what? I think I should print 3.13 and we should compare them side by side.
Yeah.
Sounds like a plan?
Yes, because it looks as though there's some more that's missing.
I feel like I've never heard that bathroom thing before, but
Well, I would suggest doing what you just said and to
Okay.
print it out.
no, I'm looking for the. Gonna kill me.
Oh.
It was, the instruction was amended in 2018. Just FYI, to add the bathroom break. Here. Here's a printed copy of 3.13 for both sides. Okay, I think this whole instruction is included except for the first paragraph.
Well, again, except for that restroom.
And the
That restroom sentence in the second paragraph, Judge, doesn't seem to be in with the Supreme Court's instructions. If a juror goes to the restroom, the deliberation should stop until the juror returns.
I think it should be included.
Okay.
Does anyone disagree?
It's fine.
I mean, it's a little bit micromanaging, but I'm more comfortable following the standard instruction, even if the Supreme Court didn't put the whole thing in the penalty instruction.
That's fine, Judge. We'll add that,
Okay.
the missing language in.
For the paragraph below that, I don't know if that's somehow in conflict with the sequestration stuff, but
Where are you, please?
many of you have cell phones on page 22.
I read it. It doesn't conflict with it, so I figured it's okay. Many of you have
Okay.
cell phones. Oh, you know what? No, I've told them not to bring. You're right. On page 22, the 4th paragraph down. Many of you have cell phones, but you cross out tablets, laptops, or other electronic devices because I specifically told them and gave them a paper to take home. Don't bring those things.
So,
I will remind them that if they did inadvertently bring that, they need to leave it in their car. But I don't want to suggest as if I've changed my mind and now am allowing electronic devices. Do you understand what I'm saying?
yes, but you want to leave cell phones?
Well, because I told them they could bring their cell phones.
Okay.
So the rules do not allow you to bring your phones or any, just put phones
Phone, to take out. or any
into
other
the jury room. Kindly leave your cell phones on your seats where they will be guarded by the court deputy while you deliberate.
So wait,
Excuse me?
they're not going to have their phones in the. When are they going to have their phones?
At night, when they get back to the hotel, there's a certain period of time where they're given like maybe 10 minutes each, I don't even know if that long, to call their family members. So It's my understanding that someone from the sheriff's office escorts them to an area where no one else, a private area, and watches them while they use their phone to make sure nothing inappropriate is discussed. That's the only time. And then they have to give it back.
Okay, so they won't be carrying them when they come
No.
back in the morning or?
No, but I think this is good to leave in because it tells them, turn over your phones now so that the sheriff's office can collect them so that they know, okay?
Judge, on the top of page 23.
Yes.
Again, from what I remember, what we discussed yesterday, and I don't know if I got it exactly right, so I'll read it, and if you want me to change it, that's fine. During this trial, it starts on page 22, last sentence. During this trial, items are received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. Prior to the start of deliberations, you will be shown how to operate the equipment in the jury room, which will allow you to view or hear any recording.
I think that's perfect. Are there any objections to that wording? That's exactly what I think we all agreed to, that Ian would go in at the beginning, not discuss the case or anything else, just show at least a few of them how to work the equipment.
Fine.
And Judge, after that, I put in firearms sent back to the jury room will be rendered inoperable, so they cannot be discharged. And if you wish to view ammunition or biohazardous material, please put that request in writing, and we will decide upon the best way to facilitate that request.
I think that's perfectly worded. Are there any objections to how that's
That's fine.
I'll leave it as is. I believe the rest of the page is
standard?
instruction.
Okay. State, are you able to print a clean copy so we all can just have a quick look?
The additions I've got it. Well, I would need a little bit of time. I've got to type in the additions.
No, just cut and paste from the Supreme Court website. Right?
Okay.
I mean, I don't want to tell you how to do your job, but that would be a lot easier, right? Maybe not.
No, I can do it.
Or we can come at 8 tomorrow and we can look at them. Or 8:30.
They also need to go. We have to go to the top of the pages and remove except for the last two, right? Rules for deliberation.
Yes. Okay, so then just do this. When you finish, if you would just email myself and the defense a copy, please, everybody before court tomorrow, review the, third amended copy of the jury instructions, just so you all know. Inevitably, no matter who does the instructions, there's like one typo or sometimes more than that. That's fine. When I read it, I will read it the correct way, and then we'll fix it before they go back to the jury. If there is one. Maybe there won't be in this case, but in almost every case, there's some kind of Scrivener's error, minor adjustment, which normally I can catch as I'm reading it, and then I will ask you all, are there any corrections, amendments, or additions before I send them back? And we will fix it.
And we'll get these to you this evening.
Is the jury going to be reading with you?
I don't normally do that, but it might not be a bad idea for people who are visual learners.
We would just have to have the copies, that's all. At the beginning. Which can be done, just.
Put it on the screen.
We could put it on the screen too.
Okay,
Yeah.
I think that's a good idea.
Yeah.
Some people don't process things as well in an auditory way? Has anyone ever taken a test to see how you learn? Most people are visual learners, myself included. So you learn better when you're actually looking at it rather than hearing it. Okay, I think everybody is exhausted, and rightly so. So just before we conclude for the day, I just need to speak to the lawyers, please, on the sidebar.
So, Craig, this is not anything unusual, both sides just kind of working out the details of the jury instructions.
Right. They want to make sure that all the I's are dotted and T's are crossed, so there's nothing that's erroneous in the jury instructions, because then catch that while you're in the middle of reading it, then it becomes a problem. So it's always safest to get it hashed out now.
This jury is being faced with lots of evidence, lots of testimony, lots to think about based on the closing arguments that they just heard today. Tomorrow they will get their jury instructions, and then they will start deliberating in the courtroom.
Correct.
The judge had said probably she would like to end things around close of business every day. And when asked what close of business was, she said around 5:30. But that doesn't mean that a juror can't say, "Hey, listen, we'd like to go a little longer." They could presumably ask for that.
Yeah, and I think if the bailiff comes in and says it's 5:30, we're calling it quits for the day, and if the jury's making headway on whatever issue they're working on, if the foreperson says, "Look, we're making some headway, can we stay a little longer?" I can't imagine they're going to say no.
Tomorrow is Wednesday, so they have tomorrow. She told the jurors to pack for, she said, a couple or a few days. We just don't know. I mean, I guess there's a possibility that they do, and if they need to stay longer, they would. Would they, let's say on Friday, if they haven't come up with anything yet, would they work through the weekend? I would imagine they would.
I think they might work through the weekend. Otherwise, they're going to be idle for 2 days, and they're still going to be sequestered, so they might as well do the work while they're there.
While they're on a roll, while everything is fresh in their minds. Exactly. So once again, you can see that there's a sidebar right now. The defendant is there. That is his right to be there. It's interesting, in the beginning of the closings, he didn't have his glasses on. He was sort of looking down. He was grabbing his head a little bit. He wasn't really engaging. For sure, not today as much as other days when he's been intently listening to some of these expert witnesses.
Right. Like I mentioned before, when that there's a difference between the answer question. That's more of an engaging thing to listen to. What we heard now are interesting summations, but essentially 5 hours of lecture.
Lots of lecturing today. The defense took about 2 hours. Well, the state did as well. About 2 hours for each, right. Give or take, with a lunch break in between. So once again, the two sides are in the courtroom. They've got their headphones on. They're just sort of like hashing out some of the details. The jury instructions are long. I mean, we saw the motion in the docket. I mean, about 92 pages.
Right, 70-ish pages of that are the multiple verdict forms. 17 verdict forms. Each verdict form is about 4 pages. So, I think it was 68 pages. So the vast majority of those 92 pages are the verdict forms. But the judge said she's not going to read all 17 of them. With 14, she's going to read one that apply exclusively.
That explain all of the aggravators for those 14 victims.
Correct, because they're all those verdict forms are exactly the same, other than the name, and then the remaining 4. Or 3, excuse me. She's going to read those because they're slightly different.
Those are the teachers, the adults who were in the school at the time, and those are different aggravators having to do with a murder, sort of like in an official building, an official function.
And an appointed public official.
Right, which I guess they're considering these teachers, coaches to be, public officials.
Right.
There was a little bit of contention about that.
There was argument about that yesterday. The state's position is that they are appointed public officials, and the defense position is that that's not what that section means. That means like a city council person or something.
Right, an assassination based on maybe a political motivation. But the state said, listen, it doesn't matter if this teacher was appointed or hired or however, they're an official working in an official capacity at the school as the caretakers of these people.
Right, but given all the other aggravating circumstances, the jury can completely disregard that and still come to the same conclusion.
Look inside the courtroom. So, by the lectern, you see all of those stacks of papers. Those were papers that were brought in by the defense earlier today, and that was part of their closing argument. I think Melissa McNeil was trying to say, look at all of the record keeping that we have on this defendant even before he committed the crime.
Right, and she said something to the effect of, you want to know who Nikolas Cruz is? This is Nikolas Cruz. All those documents, I can't even begin to estimate how many pages there are, but thousands probably.
How does a juror, let's say a juror says, well, I'd like to look back at the testimony of defense witness X who says this about the defendant, who talked about this particular study that was done on him. I mean, all of that I'm guessing is cataloged. Sticky notes? How do you go through all of that?
If they want to hear the actual testimony of that
well, that's
person,
through the clerk, right?
Well, they'll get to the court reporter, and the court reporter, they'll either have it printed and read it, or they'll come back into the courtroom.
But even just that documentation, though, how do you access that?
Right. Well, that's a challenge. That's what they were talking about yesterday. What the jury wants to see, Exhibit A. How do they find it?
Right. Whether or not that's already been done.
Where are we at with that piece of evidence? Are we ready to do it? Yeah. Is it done?
I just need, Judge, I just need S19, so I can take off the videos that we agreed to take off, and then I'll enter the new thumb drive.
Okay, so that what's in evidence will be what the jury can view and nothing more.
Yes, Your Honor.
Okay, that's a good idea. Is there any objection from the defense?
No, ma'am.
He's going to basically substitute State Exhibit 19 with only the videos that have been entered and published, right? Okay.
That's fine.
Old 19 will be the old, I'll take them.
No. You're going to keep it a State Exhibit. It's just going to be an amended. It's not a court exhibit, right?
There will be an additional court exhibit with everything on there.
But
So the other videos are,
okay, but for purposes of the jury having only what they should be able to view and nothing more, that should be a State Exhibit.
correct.
Correct.
That's not what you said.
I'm saying that the ones that he's taking off, he's putting on another drive. And that's court 11.
Yes, correct.
So I'm telling you, he's killing.
We have very, very competent people working in here, and I appreciate it. I tease them, and I mean it in a nice way. Charlene. Also, can two attorneys, well, I know, Tammy, you want to put something on the record. Will one attorney from each side, whoever is the most well-versed in electronics, go with Ian, please? Just to test out the equipment. I don't know which one of you
They're
handles.
just looking at it.
Okay. So he's going to take,
Melissa, can it be our
Sure.
paralegal?
Well, then it's
Just-
not Melissa.
as long as there's somebody from both sides and not all of you, because then it's too crowded. Please.
Aaron would be the one. but he's doing something else.
Okay.
So you won't go with the other.
Give us a few minutes.
Sure.
I'll go with Ian, and Aaron will handle the other.
I'll handle the other thing.
Thank you.
He's just going to put it in to show you all that there's only what's supposed to be on there, nothing more. It doesn't actually have to be anyone that's that savvy. Just so you all can see what the equipment is, so you know there's no internet access. Just make sure you show. Actually, I think an attorney should go too, please.
I think you're right.
I want you all just to look. He's going to show you, but he's going to. He's going to show you all, Mr. Klinger. He's going to show you that there's no internet access. But I want both of you, because I'm going to ask you when you come back, that you verified there's no internet access and there's nothing of any substance on these machines. Okay? All right. Go ahead. Thank you.
Are they going to test the drive also to make sure that your stuff works?
I'm sure.
Yes.
Ian, go with that drive with
Can you give them something to test?
Go with that.
Somebody.
He's got the CD right there.
But mainly, Ian, I would like for you to show the lawyers when you turn it on, there's no internet access, there's no, I don't know what else there would be, but
Here, here's a drive and a disc. Here's a drive and a disc. That'll work. I just want you to watch while I do this. So this is going to be recorded.
Tammy, is there something you wanted to put on the record?
Judge, I just wanted to ask to make 3 items court exhibits that we were not permitted to enter into evidence. 2 of
Can
them
this
were-
be done while these guys are working up here?
Yeah.
Okay.
I don't care. One of them is the 7 kiosk requests that I asked to enter during Dr. Scott's cross-examination, and the letter that Mr. Cruz wrote to his brother. I wanted to make these court exhibits. They have stickers on the back. And then we had filed a motion for the court to take judicial notice of the tips to the FBI.
We do these separate.
Okay.
So the first 2 things you did try to enter.
Yes, and that was denied.
Right, that's my recollection as well. So we're not going to object to those being court exhibits. They did refer to them. They did try to enter it. They probably should have done a court exhibit at that point, but that's fine. It's fine as a court exhibit, I guess, to preserve the record of their objection during the trial.
What were those numbers again, please? Or for identification numbers?
6P and S.
And there's no objection to the court receiving those as court exhibits for purposes of appeal?
Correct.
Okay, 6P is, 6P is court exhibit 12, 6S, court exhibit 13.
And the other one is, that was the second one.
Is that the subject of the motion there was a motion regarding this?
It was a motion to take judicial notice of the FBI statements,
But there's more than that.
and then the call, the post. It's all of the documents regarding the FBI, the calls, the serials, and the statements that they.
There's more than there was on the motion.
Yeah.
I give it 26B.
Judge, is it okay if I come and get some of my stuff?
Sure. Is there anything else that we need to address?
Oh, yeah, so there's one more. This is a composite of, so we filed a motion asking the court to take judicial notice of the 3 official statements of the FBI and the 2 tips, one from Mary Hamill-Thiel and one from Ben Benay, the YouTube snapshot and the serials regarding their interviews. We wanted to make these court exhibits because we were not permitted to go into these areas during the trial. So we just want this to be a court exhibit for the record.
So, Judge, we object. They never offered it in evidence during their case. They can't preserve it now. They didn't. Sorry. The purpose of a proffer is to preserve something that was denied to them during the trial. It was never denied to them to enter these specific items into evidence, and so it's over with. It's waived.
Judge, we asked during Dr. Scott's cross-examination, and we also asked to do a proffer of Mary Hamill, and that was denied. So we did request.
We did do an oral proffer.
Right, and during
That was after the trial was over. I mean, it was late then too. It wasn't during the trial that they tried to enter Mary Hamill's testimony. It was after the statement rested its rebuttal case that they asked to do that. It was too late then, and that's why we objected then. And it's still too late. They had to do it during the trial. They had to offer it into evidence, and if it was denied, then they can preserve the record by proffering it through a court exhibit. They didn't do it, and so it's waived.
Judge,
And it was about third-party negligence.
Judge, we're asking to make this a part of the record. During Dr. Scott's cross-examination, I requested that I be allowed to go into inaction prior to the offense as part of the lack of sophistication of planning, and that was denied. And the calls regarding the FBI and BSO, that was all part of it, and I was not permitted to go into that during the...
Okay, this is what I would like for you to do, and there's no rush. You can have 2 weeks if you want. I want you to file a written motion and state if you wish you can file a response, and then I will consider it at that time. But I can't remember what... There were so many motions, and I heard the issue of the FBI tips and these kind of things so many different times in the form of so many different motions that I don't remember the exact time, place, and manner at this hour, okay? So, Mrs. Curtis, I'll give you 2 weeks to file pleading in support of your request, and I'll defer ruling, okay?
Okay.
And if you would cite, when the dates and times, please, just to refresh my memory.
Sure.
If you can.
I can. Do you want these or Judge Stevens' report? These are the two court exhibits they did not object.
Clerk, please.
Judge, the state and I were able to see that there is no.
Oh, hold on. Everyone be quiet for just another second. Ms. Bashamian?
There is no internet capability. There's no way for them to figure out a way to get on the internet, and everything works as supposed to.
Okay, and state you're in agreement.
Yes, ma'am.
Okay, perfect.
It was
Thank
fine.
you. Thank you very much. We're in recess.
What time tomorrow, Judge?
I told the jurors 8:30 for a start time of 9, please.
You want us here like 8
So if you can get here, a few minutes before, 8:45. I mean,
So these are the, Craig, details of our judicial system at work, both sides going into the jury room to make sure there's no internet so they can't log on and go online, and to make sure that everything works.
Yeah, these are the things that you don't want to have to find out they're a problem at the time they're a problem. You want to figure it out all beforehand and make sure there's no problem starting tomorrow so everything works smoothly.
The defendant, as you can see, is being led away. Tomorrow he will be there as well when the jury is being read their instructions. I know you haven't been into this particular courtroom, but when the jurors go into their deliberation room and there's all of this evidence, right, the weapon, and there's some of the, as we can see sitting out there, the boxes of evidence that's just from the defense. Right. So what is it? Is it all in the jury room, and is it like a pile over here that says state and a pile over here that says defense?
Pretty much, yeah. And there was a discussion yesterday of how they're going to try and catalog all this stuff in order to find things that they need to find. Because I think the last count on the state's exhibits were 490-ish, somewhere in there. There was, a couple of thousand pages on that table there that the defense presented. So there's a ton of evidence to go through, and that doesn't count if they want to hear a witness's testimony back, in which case they'd have to send a note out, and then that testimony, the court reporter would find that portion of the transcript and read it back to them.
And I'm guessing then there's some sort of TV with an audio-video capability, because not only is there written documentation that they can physically go through, but also we saw videos. We saw some cell phone video as well.
Yeah, and they sent one lawyer from each side went back to the jury room where all that technology is, and they just went in there to confirm that, one, the technology works, so they'll be able to play those items if they want to play, and two, there's no way that they can get on the internet in that room through that technology, which is always a concern.
So right now the jurors are presumably on their way home. They'll be packing their bags tonight. They'll be back in court at 8:30 tomorrow morning. The judge says the start time is 9 o'clock. We'll be starting at 9 o'clock as well. We will see you tomorrow.